Hi, what's going on, everyone? My name is Bob White, and I'm excited to welcome you here to this video where I'm going to be going over 10 things that you absolutely must know before you take, or if you're like me, before you retake the bar. That's right, I took the bar multiple times. And what I really want to do here, what I've really tried to do with my company, is to take the lessons that I learned in between the first time when I didn't get the score that I wanted, didn't get a passing score in my jurisdiction, right? And then what I learned in between, how I studied, what I studied differently, and the different approach that I took that allowed me to ultimately have some success on the bar. Okay, so 10 things you absolutely must know before taking or retaking the bar exam. Number one, you can pass this exam. Now, that's not the same as me saying anyone can pass the bar exam. Obviously, the bar exam is incredibly difficult, and not anyone can just off the street sit down and pass it, or not anyone can sit down, study for a couple months, and then walk in and pass it. But you, I'm confident you, the person watching this video, if you've made it through law school, if you're eligible to sit for the bar exam, then you can pass this exam. The bar exam is not as hard as getting through law school. The type of analysis, the type of thinking, the mental rigor that you have to go through to get into and then get through law school, I promise you, is more difficult than the bar exam. And what makes the bar exam difficult is we've just spent 3 years going through learning how to think a particular way, right? Learning how to approach problems in a particular way, learning how to do a particular type of thinking. And it's different than the thinking that we have to apply on the bar exam. So we're going to get into this, but the first point that I wanted to make is that you can pass this exam. If you don't believe that you can pass this exam, you're not going to pass this exam. The first most important fundamental thing, right? It's like they always say, if you believe you can or you believe you can't, you're right. That is true in every area of life, and especially so on the bar exam. So before we go any further with anything that I talk about, it all has to start with the idea that you can do this. And again, that's not me saying anybody can do this, but I'm confident that if you're watching this video right now, that you can do this. Okay, so if that's our first one, what is the second thing? I talked about a little bit, I said a minute ago, how this is a different type of thinking than we've done in law school. And the second key that I want to give you, and that it sounds counterintuitive, but I believe any good bar instructor will probably agree with this, is not a law exam. There are questions that deal with law. It's easy to say that this is a law exam, but if we really get into it, and bear with me for a second, this is not a law exam. This is not an exam that is going to test your abilities as a lawyer, your abilities as a litigator, your ability to think creatively, to get outside of the box, to problem solve in the way that lawyers problem solve. None of those skills, and I'm talking mostly about the MBE, although this relates to the essay and the MPT as well. We're not going to do the type of thinking, the type of analysis that allowed us to succeed in law school. You might do a little bit of the IRAC format. We'll talk about that with the essays, but this is not a law exam. And so real quick, I remember the first time I took a bar prep exam, right? The first time you do the diagnostic or whatever. And I went into it with the approach that, okay, this is going to validate the 3 years, whatever, that I've spent in law school, and I'm going to show what a great attorney I have learned to be. Do the questions, go through, and I got 55% right. As just about anybody who goes through law school and then sits down and takes, an MBE style diagnostic test, you're going to score about 50, maybe 60%. But the point is, this will make more sense when I go to our third point, right? Our third thing we must know. So the first, right, you can do this. The second thing, this is not a law exam. Okay, so Bob, what is it? Well, my third point here is that this is a vocabulary and a reading comprehension exam. And again, specifically MBE, although this applies to the essays too, this is all about vocabulary. This is all about, can you speak, think, answer questions in the same language in the same syntax that the bar examiners are using, right? Because all this is going to come down to, as we'll see, this is about definitions. This is elements. Each concept, each rule that we're going to talk about has particular elements. There's going to be a test that goes with each, and you're either going to have all of the elements met, and we're going to have a condition satisfied, right? So for example, let's talk about something that seems relatively simple, adverse possession. We know that adverse possession has these elements, right? A person has to be an actual possession, open, hostile, right? It's not permissive, notorious. You have this list here. If any of these are missing, right? So I didn't say the exclusive element just now and I was going through it for a second. Let's say that element's missing, then we don't have an adverse possession. We don't have a valid case of adverse possession, right? All of those elements are not met, so we don't have adverse possession. And so how do the bar examiners ultimately test a lot of this stuff? They're going to test it on definitions and how well you can closely and carefully read. One of the things that we'll see as we go through this, the bar examiners love to play on your anxiety, right? My anxiety, the test taker's anxiety. They're going to get you to psych yourself out, to overthink these questions, or sometimes to underthink them, right? And this is a classic problem that every bar taker has, where we want to fly through these questions. And why do we want to fly through these questions? Because who wants to sit and read 3 paragraphs of civil procedure, right? I don't. No one does. No one wants to sit and actually read those sentences closely. And let's take a step back and think about how we learn to read in law school, right? There is no way you could get through law school if you sat and closely studied every single word of every single case that you were assigned to read in law school. There's just not enough time to do that and still function as a normal human being. So what did we do? We learned how to read strategically, selectively. You could look at a case, and by the time you're in your 3rd year of law school, you could be half drunk, half asleep, whatever, kind of doing the one finger skim, and you could find where the holding was in that case, right? You could find the key takeaways. You could do enough that if you had to talk about it in class, you could kind of hack your way through it. And there's nothing wrong with that. There's nothing wrong with that in terms of getting through law school and learning how to read to get through law school. But on the bar exam, the bar examiners know that. And so what the bar examiners will do is they will change a single word, a single phrase. They'll add something to a familiar fact pattern. They'll take something away. And if we're not reading closely, we'll miss it and end up with totally the wrong answer. And multiple choice, it's either right or it's wrong. There's no partial credit. And so, stupid answer, stupid, I misread that. I missed that point. Well, if we go too quickly through this, and this is one of the mistakes I made the first time I took the bar exam, I was like, yeah, okay, I know this. Wow, thank God, I'm recognizing things. I see that term. There's a buzzword there. And you go quickly through it. You go too quickly through it. And, 6, 7, 10 dumb mistakes. Well, in some cases, that's the difference between passing and failing the bar exam. I mean, again, I've been a repeat taker. The whole key, this is about approach, and what I want you to get from this third point here, that this is a vocabulary and a reading comp exam, is that let's say you got your bar score back and you didn't do particularly well. When I took this, I was in like the single-digit percentiles for civil procedure and for property and for contracts. Now, that doesn't mean that I didn't know any of those concepts, although, although I certainly didn't have a lot of confidence when I was sitting in your shoes, a day or a week after getting those bar results. But here's the key though, right? These mistakes, these things that are leading us to get the wrong answers, it's not because you fundamentally didn't understand anything that you learned in law school for the last 3 years. Of course not. Your law school wouldn't have given you a degree if you didn't understand any of this. Of course you understand it. The idea is we have to now apply all of that thinking the correct way to these types of questions. And a lot of times, as we'll see, what that means is we take all of that analytical thinking that we've had, that we've learned to do, kind of put it in a box, and we set it aside, and we only apply our powers of focus, right? We only focus on what is right there in front of us, and what we'll see is that this is not a law exam. This is an exam that is about reading comprehension and vocabulary. So that's my third point, reading comp and vocabulary. So what's the fourth thing that you have to know? There are no tricks on the bar exam. Any bar instructor that's worth their salt will say the exact same thing. There are no tricks on the bar exam. Bob, what are you talking about? I just took the bar exam. Every question, there's some kind of trick. They're doing something to you in every question, and I agree. But here is the key. There are no fundamentally unfair or, trick questions. There's no question that if you read carefully and you understand what they're doing to you, there is no question that you can't figure out. Now, am I saying you're going to get all 200 questions on the MBE correct? No, of course not. Nobody does, because you're sitting there, you're doing it all in a single day. You're in the convention center. You got all these people around you, all the stress, everything. You only got one shot every 6 months to take this thing. So no, you're not going to get all 200 questions right. The good news, you don't need to get all 200 questions right. All you need to do is just do a little bit better than the person who didn't prepare as well as you, the person who doesn't understand how to think about this in the way that we're going to be talking about it. The biggest difference between people who are going to pass and not pass the bar exam, well, really there's two. The first, simple, it's just preparation. A lot of this is going to be time over the target, right? Hours of repetition. We'll get into how to handle that. But the other biggest thing, and this ties in with everything I've said thus far, it's going to be people who are approaching it like it's a law exam. Like I'm going to be able to use what I know as a lawyer to be able to think through, to be able to reason through these questions. I'm going to be able to look at, A and then B and then C, and I'm going to be able to say which one's better. No. That is the problem that people get into with this. And the bar examiners know, and we know from taking multiple choice, SAT, LSAT maybe, there might have been cases where there really were two answers that arguably could have been correct. Potentially, right? I mean, there's some multiple choice cases, some multiple choice tests where arguably you can say that one answer is more correct than the other. And usually that's a function of the test writers being a little sloppy. That's not going to happen on the bar exam. On the bar exam, there is only going to be one answer that is correct. Now, there are going to be other answers that contain statements that are either legally, factually true, or sometimes both. There might be an answer that contains a statement that is both legally and factually true. But, and we're going to talk about this and if we get into the actual law videos, what you're going to see is that oftentimes the bar examiners will put an answer that is legally and factually true that has nothing to do with what the facts are talking about. A classic example of this is when we get into the area of search and seizure, right? And we know that the bar examiners, when they do criminal law, they do murder, manslaughter, homicide, larceny, all that stuff with the criminal procedure stuff, right? Well, what can the police do? Constitutional protections of accused people, all of that. And so what the bar examiners will do is they will say that the cops had probable cause, that Bob is a drug dealer and I have all this cocaine in my house, and the cops come and they break down the door and they seize all the cocaine. And the facts will be very explicit. The cops didn't have a warrant. Now we know, okay, just because there's probable cause, if there's no warrant, that the police can't go and search in an area where there's a reasonable expectation of privacy. If all that doesn't make sense to you right now, don't worry about that. This is just for the purpose of this example. The point is this. Answer choice A is probably going to say something like, well, the search is inadmissible, or the evidence, the cocaine that was recovered is inadmissible because the police didn't have a warrant. Answer choice D is going to say something like, it is admissible if Bob consented to the search. The facts, however, don't say, they're not going to say anything about consent. So while it would be true that if I consented to a search, that would give us an exception to the warrant requirement and that would allow that evidence to be admissible. And particularly for those of us that practice, in the real world, we have a tendency to, in whatever area of law you've studied and are planning to practice in, right? We have this idea that we're going to apply what we know, what we've learned to the bar exam. And that is wrong. That is like as wrong as you can be as you're approaching the bar exam. And we're going to get into why that's the case in a minute. But what I want to say here, and again, we're still talking about how there are no tricks on the bar exam. You might look at that and say, oh, well, that's a tricky answer. That's a trick answer, because if Bob consented to the search, that would be an exception to the warrant requirement. And that's true, right? That's legally true, but that's not what the facts are talking about. And so the key here is we're going to always look for the most specific answer to what the facts are talking about. And what we'll see as you get through doing some of these questions, and not just doing them, but really thinking about them, being able to recognize what the bar examiners are doing to you in different particular areas. What are the bar examiners doing? And one of the things that you're going to see is that in each particular question, there will only be one answer that has the correct elements and is talking about the facts of the fact pattern. So really, to get to that third point I made, that this is a vocabulary and a reading comprehension exam, if we read closely, if we understand what issue they're talking about, and we have memorized, and we know we have stone cold memorized the elements of each of these issues that we're going to talk about here, each of the issues in the outline that the bar examiners give you. If we know those elements, then we use our powers of analysis and reasoning to look at the answers and say, okay, only one of these answer choices is going to be talking about the elements that we know this question is asking about. Okay, so we said there are no tricks on the bar exam. Here's the way I would say it. There are no tricks on the bar exam, but there are techniques, or if you prefer, there are tactics that the bar examiners use, right? And one of the things that I talk about as I go through videos and kind of what my method is we try to identify what the BET, the B-E-T, the bar examiner's tactic or the bar examiner's technique that they're using in every question. And I promise you, if you learn to identify that and you can see what they're doing to you in these questions, you will be amazed at how easy these questions can seem. So in sticking with the theme of this video, write 10 things that you have to know before you take or retake the bar exam. Number 4, we said there are no tricks, but number 5, there are techniques, and we have to learn what these techniques are. There's this famous line that if you know your enemy, you don't need to fear the result of 1,000 battles. This is exactly the same concept here. If you know what the bar examiners are trying to do, if you know the 3 or 4 ways that the bar examiners try to test you, you don't need to fear 1,000 bar questions, because in those 1,000 bar questions, as long as we read closely, as long as we have our definitions down and we can identify what it is the bar examiners are trying to do to us, we're going to be just fine. So just like that, we're halfway through my list of 10 things. That leads us to number 6. Time is your friend on the bar exam. That's right, time is your friend. You have much, much, much more time than you need on the bar exam. Now, of course, there are going to be different circumstances and conditions where you need extra time on the bar exam, and you're somebody potentially who's eligible for that. By all means, take advantage of that, pursue that. Let's say you don't qualify for any type of extra time. That's fine, because again, assuming that you go about this the right way, as long as you can read at the level that you needed to read to be able to get through law school, you're going to be just fine on the bar exam in terms of time. Why is it that people find that they're short on time on the bar exam? Well, if we don't apply what I've talked about so far in this video, right? If we don't think of it as a simple reading comprehension vocabulary exam, this list of 3 or 4 techniques that the bar examiners are going to use. If we don't do that and we try to think through this like a lawyer, right? We try to think through this, analyze what's going on, compare answer choice A to answer choice C to answer choice D. Wait, let me go back to the facts. I don't remember if they talked about that. You can see that's what's going to take a lot of your time. That's what's going to be a problem for us, right? If we are spending time thinking on these questions, we don't have time. If we are reading and just like a robot, like a computer, just pulling from memory, recognizing, okay, I know this is a question about an easement and whether or not the easement was validly terminated. Well, I know in my head the rules for easements, and I'm just applying. There's only going to be one answer choice that talks about an easement being terminated, and let's say if it was going to be abandonment, let's say, there's only going to be one answer choice that talks about the elements of abandonment of an easement. We don't need to get into what all those are right now, but this is the point. Every bar instructor, right, every bar textbook will say that you have anywhere between 1.7 to about 1.8 minutes per question, right? 1.5 to 2 minutes, depending on how you break that down. And the reason why it varies is that we know some of these questions, particularly think con law, justiciability, right, or some of the Article 3 questions they give you, the fact pattern is this long. It's 3 paragraphs. And we'll see one of the techniques the bar examiners do. They'll intimidate you by giving you a fact pattern that takes up one whole column of that page in the MBE book. Who wants to read that? You're thinking you're 1 point out of 200. I'm not going to waste my time reading this whole thing. I'm just going to pick the Latin answer because, well, one time on this exam, the Latin answer is going to be right. If I pick it 4 times, 25, don't do that. Don't do that. Because here's the thing. If you spent a minute and a half, which if we think about it is a long time to just be sitting and reading something. If you spend that entire time looking at what's going on in the facts and doing what I've talked about so far in this video and what I talk about in all my other videos, which is reading comp, getting the vocabulary, and then identifying what technique, what tactic the bar examiners are using to test you, if we can do that, we only need to spend a few seconds in the answer choices. And again, where people get in trouble is when they start analyzing the answer choices. There's only going to be one answer choice that's correct. The other answer choices are going to look good. And by the way, the bar examiners often have ways of making the right answer choice look less attractive. So the key is not to look at the answer choices, right? And the classic example I've heard used, I think it's actually a really good one, right? Is like if you're going out to eat, if you know what you want, you don't need to sit and look at the menu, right? You look at the menu till you find, something that aligns with what you have an appetite for, and you order that. If you are, you can spend, particularly at a good restaurant, you can spend an hour going through, at least I can, you could spend an hour going through comparing one thing to the next and wondering which one of these is better. Well, I don't know, that one hits some of the things on my list and that one hits some of the things on my list. Don't do that. Do not do that on the bar exam. If you spend time comparing answer choices, you're going to have a time problem. If you apply this system and you do it the right way, time is your friend on the bar exam. So that's our 6th point. Okay, so picking up steam here, we move on to number 7. And again, this kind of fits in perfectly with what we've said so far, because I am sure that as I've gone through doing this video, I've repeated myself a number of times. That's okay, because the bar exam is all about repetition. This is going to be all about how many times you can drill these concepts into your head. Now, a great example, analogy that I've heard, if you think about like a TV show or a movie that you really like. 2 favorite shows of all time are The Office and Arrested Development. They're like on in the background all the time in the house, right? I'm one of those guys that I could, again, I have to have the episode up. I can't do it from memory, but I could give you probably every line in The Office and every line in Arrested Development. The reason I can do that is because, again, they've been on in the background. I've seen every episode of those 2 shows, 15 times, more than that probably. Here's the point. I never made an outline. I never sat down with flashcards. I never studied those TV shows, right? I never studied what those lines were, but I saw them enough. I heard them enough. I heard one line followed by another line, right? And your brain makes those connections. You memorize it. And so it's like how you learn a language too, right? It's immersion. And that is the way that we have to study for the bar exam. It's going to be repetition. It's going to be going over these definitions over and over and over again. And that's why, quite frankly, a lot of people struggle with the bar prep content that's out there. You don't want to listen to, no offense to them, but you don't want to listen to the Barbary guy drone on hour after hour after hour explaining something that you never really understood anyway, right? So it becomes painful to sit there and listen to. Good news and bad news here. There's no way around it with the repetition. There's absolutely no way around it. You have to spend the time. The good news is, give yourself the 2-3 months, and what I've tried to put together here is hopefully a program that's fun, engaging, a little interactive. Make it so it's not so miserable. You spend the time doing it. I promise you, just like, for you, maybe it's not The Office or Arrested Development, maybe it's another show, but think about that. You don't have to think, you don't have to stress to know what the next line is, right? What that character is going to say in that situation, because you've memorized it. And that's how we have to approach these definitions for the bar exam. What I've tried to do is come up with a way to make it fun, make it exciting, and hopefully we'll see that as we go through. But that's the 7th point here. Repetition is the key. Repetition is the key. Just for good measure, repetition is the key. Okay, so number 8, and I said I wasn't going to get into too much law in this video. This is just kind of tangentially touching on that. Here's the idea. In every MBE question, there's going to be an issue. We have to be able to identify the issue, right? What they're testing about. Otherwise, we have no chance getting the question right. But once we identify, the rule, the issue that's there, and if we've done a good job, everything I've talked about so far in this video, if we've done a good job with the repetition, we understand kind of what the base rule definition is. And you love talking about all of those hearsay exceptions, right? You want to be a trial lawyer, and so you know all of the different ways to argue this piece of evidence that would maybe, but for your brilliant legal analysis, be inadmissible, but you found the clever argument that makes it admissible. All of that thinking, it's great for the courtroom. It's great for real life. It is a poison pill. It is terrible. It is awful for MBE. We cannot be doing any type of that thinking on MBE. And this is really the point that I want to make here, the rule is going to be tested much more often. 90 to 95% of the time, the rule is going to be tested, not the exception. So what we're going to see is that hearsay is a great example. We know, just as a basic kind of black letter law, what's the definition of hearsay in terms of admissibility? Hearsay is not admissible, right? Just that answer. If it's hearsay, it's not admissible. Of course, there are exceptions to that. A lot of you are going to have jobs just based on the fact that you can argue why things are hearsay and why they're not, right? But again, if we're thinking about a question on the bar exam, we have to always apply that black letter law, the simple base definition first. Now, this is going to make more sense when I tie it into my next point here. Number 9, this is my favorite of all 10. Remember, they are testing, they being the bar examiners, are not testing you. They're not giving the exam to me, to Bob White from Boston. They're giving the exam to everybody. And so you or I may remember a particular case. Maybe we were involved in a particular case. You have some knowledge that's either from your jurisdiction, maybe it's federal law, whatever. The point is you know something. You have things in your head by virtue of your legal training that quite honestly only you know. The point is that the bar examiners don't care about that. There's no way to test that. The only thing the bar examiners can test as far as giving a fair, right, which it has to be fair, who's more litigious than a group of people who, are about to become lawyers, right? You want to sue everybody. The point is this. The only fair way to give an exam to that group of people is to say, hey, here's the book, the file of all the definitions, all the rules, and we're just going to test you on how these rules might look in different situations. But all we're going to be able to work with is just these definitions. It either is the definition or it's not. Either all the elements are met or they're not. And so what we have to remember for the bar exam is that they're not testing you, they're not testing me, they're testing all of us. And what's the only thing that all of us collectively can know? those definitions, right? It's not quite this literal, but it kind of is. What does it say in the Black's Law Dictionary, right? I mean, if you know the black letter law definition, and you remember my last point, which is the rule is being tested more than the exception, and you're really good at that earlier stuff I talked about, right? Reading comprehension, vocabulary, and you avoid analyzing or litigating these questions, you are going to be in much better shape. Where people get in trouble is they say, oh, I remember this case that I read. You see something, thank God I read that case, because otherwise I wouldn't know what they're talking about here. That's wrong. Don't do that. They're not testing you, they're testing everyone. So that's again, it's my favorite one, because I know when I had someone explain that to me, it was like light bulbs going off, major breakthrough, because I was able to get away from, you take that first or second diagnostic test at the end of law school, you want to feel like your efforts have been validated, right? That you know something, that you're a good lawyer. The problem is that what's going to end up happening is you get that 50% and you're like, oh, I'm a terrible lawyer. I'm never going to pass the bar exam. What the heck did I just spend all this money for? Don't fall into that. Don't get down that road, because quite honestly, it's if people who are getting down that road get down on themselves, feeling like they can't do this, it becomes that self-fulfilling prophecy when they go to take the bar exam. If we know that they're not testing you, but they're testing everyone, it makes it a lot easier for us to not be so emotionally involved with every question, right? Not be so, and even more than that, not be emotionally invested in the conclusions that these questions are making us come to. It makes it much easier for us to pick an answer that we're like, okay, wow, in real life, this would never happen. But for MBE world, for the bar land, okay, I can understand why that's the correct answer. That's the one that we need to choose. And now to round it out, it kind of, I think, brings everything together. It's hopefully the theme, a lot of what I've been talking about here and what goes through all of my videos. Don't panic. Number 10, don't panic. So much of being able to pass the bar is being able to stay calm, cool, and collected, remembering those things that we've talked about thus far in this video and applying them to an individual fact pattern, an individual question. A great kind of expression. You hear it in the military a lot, but also in other circles. Slow is smooth, smooth is fast. That's a big part of my brand as I try to go through this. Because like we talked about earlier with the time being your friend, if we take our time, if we have a really good foundation, if we know the definitions, right? If we know what they're trying to do, we can recognize that BET, the bar examiner's technique, in every question. And we take our time going through. Before you know it, we're going through, we have a really smooth understanding of what's going on, and we don't need to go back and interrupt our thought process by comparing answers and then going back to the facts and then going back to compare answers and then thinking about, well, is answer A really better than D, but C is really saying the same thing. We can avoid all that herky-jerky jumping back and forth if we take our time, right? Slow is smooth, smooth is fast, and we don't panic. We don't panic, we're gonna be okay. Here's another cool thing I'll tell you. When you get that book of questions for the MBE, you're sitting there and they give you the book, and even before you break the seal on the book, all of the answers, everything you need to know is contained right in there. Now, if you haven't prepared, if you don't know the right way to approach it, that's not going to be particularly helpful. But if you have prepared the right way, if you do have a solid foundation going into this, and you don't panic, even if an individual question seems at first glance really hard, gosh, Bob didn't talk about that thing, take a step back, don't panic, and let's think through this system. Let's use our system that we've learned, and we're going to be able to see in a minute, no more than 2, this is what the bar examiners are doing to me. Now I know what the right answer is. I don't have to be afraid of this exam. Just to recap, here's our list of 10 things that you absolutely must know before you take or before you retake, and I hope you are willing to retake the bar exam. You can pass this exam. It's not a law exam. What is it? If it's not a law exam, it's an exam about reading comprehension. It's an exam about vocabulary. Remember, there are no tricks on this exam, but there are techniques. There are tactics. We have to invest our time in learning what those techniques and tactics are. If we know what those techniques and tactics are, and we're good about our reading comprehension, we're good about our vocabulary, then time is our friend. Time is our friend on the bar exam. And I'll say it one more time because repetition is key. Time can be at least your friend on the bar exam, right? We also have to remember that the rule is going to be tested a lot more than the exception. We need to know the exceptions to the rule, but before we start worrying about exceptions, we got to make sure we know those rules and what's the best way to get in that mindset of learning the rules, of kind of getting away from stressing about the individual outcome of a particular question, what conclusion they're making me come to. They're testing everyone. They're not testing you. You might have spent a ton of, you might be the best criminal law lawyer. You know, you're going to go and be the U.S. attorney for your state. Love it. Awesome. Not today. Not in 3 months when you take the bar exam. You got to do it this way so that you can go and practice the law that you want to practice, so that you can go and do all that fun stuff, make all those brilliant arguments that I know you're going to make soon. First, we have to remember they're not testing you, they're not testing me, they're testing all of us. And what's the most important thing? Don't panic. Please, if you take nothing else away from this, the first and the last thing, that's all I want you to remember. You can do this so long as you don't panic. And so thank you for tuning into this video. If you like my style, if you like the way that I'm going about this and you want to get into some more specifics, check out some of the other free videos I have here on the YouTube page. Obviously, onealanback.com is our main website, and then you can go in and see specifically some of the programs that I have. If you are prepping for the bar, Beat the Bar is a comprehensive program. I go through all of this stuff, not just the techniques, but obviously the black letter law itself. But until next time, I love each and every one of you. I believe in you. We can absolutely do this. We're going to get you over that goal, passing the bar exam. See you next time.